Everybody, back to another episode of AML Detectives. Today we have a very special guest on our show today, Ross Delston. Thank you so much for joining. It's a pleasure.
Thanks, Justin. Delighted to be here.
It's good to hear. Well, Ross, I know a lot about you, and a lot of people out there know a lot about you. You can shake your head if you wish. But for those out there that are unaware of Mr. Ross Delston, can you give a little background about yourself?
I'm not sure, Justin, we should waste our time talking to people who are not aware of my background. But yes, I have been doing AML CFT, Bank Secrecy Act work for approximately 22 years, starting in July 2000, a year before 9/11. I started out working with the IMF, International Monetary Fund, drafting laws, training officials, and working on what is the functional equivalent of a mutual evaluation report that the FATF does. But the IMF also does these, and they're called detailed assessments. So then I worked for the IMF for 5 years as a consultant, went out on my own in 2005, back out on my own in 2005. Been doing independent audits, 20 expert witness engagements, including for the Southern District of New York U.S. Attorney's Office, more recently the Securities and Exchange Commission, civil, criminal arbitration cases. Also worked on the monitorships for AIG and BNP Paribas. So enough about me.
Now, I was going to say we probably need more time. That's pretty impressive. A few things. I know you're modest. It's all right. Don't worry. All right. So I've always wanted to ask you this. You've been involved in a lot of cases in your career. What is one that stands out that had a lot of AML failures, and what did the company do to fix them?
Well, I can't talk about specific cases, but I can give you an amalgamation. What typically happens with the big ones where everything has gone wrong is that there is a failure not just at the top, but at every level. So you see all sorts of things going wrong. An example from one case was my request talking to the compliance officer, would you mind sharing your escalation procedures for suspicious activities? She says, well, they're not written down. So, yeah, I didn't laugh.
Okay, good.
Laugh. I was biting my tongue. But that's what you get in a situation where nothing is quite right. And she wasn't kidding. She saw nothing wrong with that. Wow. Regulators, of course, in the US will tell you if it's not written down, it doesn't exist. So they don't want to hear about it. What would be another one? Well, a debate about screenshots. If you're going to a website to conduct enhanced due diligence, or for that matter, to do a sanction screening, because it changes minute to minute. So you take a screenshot, debate. We've never done that. Yeah, but you've never been in this kind of trouble before. What are we debating? It takes about 5 seconds to do a screenshot? Yeah. And then you put it in an electronic file. You don't need to print it out. And that way the regulators always, any regulator comes by later. Did you check this? Yeah, here it is. All sorts of, this was my first expert witness engagement. They asked me to take a look at this was a civil fraud case. But take a look at this complaint in a different case. So I ask a lot of questions. Why? This has nothing to do with our case. Just read it. So the complaint, as you know, is a narrative description of the claim against the defendant. And it started out by saying, Mr. Fraudster and I were incarcerated together at I'm making this up, New Jersey State Prison. And when Mr. Fraudster got out of prison, he approached me and asked me whether I'd like to invest in his real estate venture. Now, why was he in prison? This was his cellmate who would have known this. He was in prison for real estate fraud. Remember, this is a complaint, meaning that his cellmate, his old cellmate, had gotten defrauded. And now he wants his money back. Now, wait a minute. You invested with a convicted fraudster. Now you want your money back. So I call these WTF moments.
Yeah.
I think your audience knows what those are.
Yeah, I'm not going to break down specific acronyms, only those of regulators, rules, and regs. How about that?
Okay, good. I like that rule.
Yeah, I just created it a minute ago. But so curious, like I've heard this term and you've heard this term, the cost of doing business, right? Like I've seen some firms, and I've even worked for some firms where they've been fined an enormous amount, but their revenue always exceeds the fines that they receive. You've seen that before in your career, right?
Well, certainly AIG and BNP Paribas are examples of that, and I worked on both. But yes.
And what did you take away from it besides frustration?
Well, very hard to change the corporate culture.
Yeah.
We always talk about tone at the top, but again, it's top, middle, and lower ranks. It's permeates the place. In AIG, they just didn't believe in compliance at all. They had no compliance to speak of in any area. It wasn't considered to be important enough, and they had a competitive advantage over all other insurance companies by not having a compliance program. So to put one in place, really, really difficult.
So where do you think the message gets lost? I know that it's supposed to stop at the start of the top and trickle down to the lowest level, but where does it typically get lost?
Again, it's everywhere. I often hear the term, we need to get back to BAU, business as usual. So you're laughing, but and it is funny because, let's stop here a minute, guys. It was BAU that got you into this mess. Now you want to go back? Really? So maybe that's the wrong term. Maybe it should be the new BAU or the modified BAU. But to say, oh, we're anxious to get back to BAU, that doesn't work for me. Isn't
their interpretation of BAU leading to problems? That's why I'm laughing. Like, that's not where you want to go to. You want to get away from that and create something, I guess, a good BAU.
Well, something new and better, but often you don't see that. And then you hear these funny things creep in. For example, a classic trope is, we shouldn't be part of law enforcement. They're making us into an arm of the police. When you hear that, when I hear that, I don't know about you, when I hear that, I know there are problems, because that's the sign of somebody, one, doesn't understand it. This isn't, banks don't do investigations the way law enforcement does. They don't have the power. All they can do is look within their four corners for something that might have gone wrong with a client or an account. So that's not law enforcement. And two is, it's resistance. It's kind of passive resistance. We shouldn't be doing this. Well, guess what, guys? The FATF came out in 1990. It's been 32 years now, and you're still talking about not being part of law enforcement. I expect with the Enablers Act being debated in the Senate, I hope, that the real estate agents will be saying the same thing. We shouldn't be part of this. The lawyers will be saying the same thing, attorney-client privilege. Gee whiz, guys, I'm a lawyer. How is it that the Law Society of England and Wales, our mother country when it comes to common law, has adopted the FATF recommendations with respect to lawyers, and yet we say it's impossible. And the answer is, it's fairly simple. The answer is, there are lots of areas where attorney-client privilege does not apply at all. For example, negotiations with third parties. Anytime there's a third party in the room, anytime the third party gets a document between an attorney and a client, but it's shared with a third party, for example, due diligence, no attorney-client confidentiality there, no privilege. So there are lots of areas that lawyers can report suspicious activities and should report suspicious activities. And also, unlike a major New York law firm in the Wolf of Wall Street case, one of the best named cases, U.S. versus Wolf of Wall Street. Look it up. Yeah. And this is a civil forfeiture case brought by one of the U.S. Attorney's offices. Might have been Southern District. When I started working with Southern District on a case, I told them that I knew that everybody else was afraid of them, but I felt I needed to tell them that I also was afraid of them. And they laughed. They are a fearsome bunch. So they bring these cases against property that has been used either as part of a crime or generated from a crime. And Wolf of Wall Street was a movie, pretty good movie, that the one MDB, the Malaysian Sovereign Wealth Fund, don't ask me what that stands for, one Malaysian Berhad something, and they invested through a fraudster close to the ruling family in this movie, and now the U.S. government was trying to take it back. Now, in that civil forfeiture complaint is a description of a major New York law firm that received millions of dollars in retainer fees. These are advanced fees to pay for future stuff. And then they would get instructions from the Malaysian fraudster who was looting this multi-billion-dollar fund. And he would say things like, I'd like to buy a hotel. Would you wire the money for, it's a great hotel, the Hermitage. Yeah, I stayed there once. This is where they put people up for the Academy Awards. Amazing. I'm on the phone with my wife. I'm in California. She's in Washington in those days. The kids were young, and she's complaining about, she's having cold beans for dinner. And I said to her, excuse me a second, but I hear a knock on my door. It's my lobster bisque being delivered. And she said, but I'm having cold beans. I said, we've got a microwave, heat them up. So the point of this story is great hotel bought by the fraudster, and the law firm willingly went along with using their retainer funds for the purchase. Retainer funds are supposed to be used to pay legal fees and expenses, not to buy stuff. All they had to do is say, I understand you want to buy this hotel. We'll wire the money back to you and you can buy it directly. But no, because the fraudster wanted the name of the law firm in the chain of the wire transfers.
That's incredible. Well, listen, Ross, this has been an absolute pleasure having you on today. Definitely come back. We learned a great deal about your background and what you've been up to, but thanks again for joining.
Justin, it's been a lot of fun, and I hope you'll invite me back for part 2.
Sounds good, Ross. Thank you.